Welcome to the Deal Doctor live stream for Monday, December 13th, 2021. You've heard me say for many years that the number one cause for real estate lawsuits in the state of Michigan is blanks in contracts. And while that may be statistically true, I'm going to change it just a smidge, just to tweak it just a little bit and say that, in my view, today the most frequent cause for real estate lawsuits in Michigan is misunderstandings between the two parties, between the buyer and the seller. Misunderstandings, not necessarily the absence of language in the contract, the blanks in contracts, but that the language in the contract is not clear and therefore ends up with interpretations, different interpretations between the two parties. Take, for example, what is a right of first refusal? Who is refusing what and when? Isn't it a first right of refusal, as we hear it often referred to? And the answer is no, it's not a first right of refusal, it is a right of first refusal. Because a first right of refusal implies that there's a second right of refusal, which there's not. So, a right of refusal, a right of first refusal, gives the buyer the option to first refuse to do something. What is that something? Well, that's where it gets a little bit hinky. For example, one common thing is removing the contingency for a buyer's home to sell. Another is that when you have a renter in a property, sometimes the landlord will give that renter the right of first refusal to purchase that property at a given amount or to meet the competition, meet an offer by a prospective buyer. So the question is that when you have a right of first refusal, you have to identify what is it that you are that buyer has the right to refuse to do. For example, if you have a buyer's offer come in and it includes a right of first refusal and their home has to sell, it's not on the market or it hasn't received an offer yet, then that they may ask for a period of time where they have the right of first refusal to remove that contingency regarding the sale of their home if another offer comes in. And that may be 48 hours, it may be 48 hours from the time they get another offer, all of those kind of options there. The problem is that sometimes it's not clarified, that it's not identified what the options are and the time frame in which that buyer has the right to remove that contingency and proceed toward a closing. Moreover, the question that a listing agent should be asking is, if a buyer has a right of first refusal, if you've given that to them in the negotiation process, are they able to remove that contingency should another offer come in, regardless of the time frame? Are they able to go and get a loan and get the loan approved if they still have their house for sale? That's a question that a listing agent should be asking in the event an offer comes to them with a right of first refusal included in it. What happens if the buyer gets an offer on their home and now has their home considered sold? The question is, does that trigger the first sale, the sale that the buyer is attempting to complete on the seller's home? Does that then trigger that as a pending sale? Well, maybe, maybe not. Does it satisfy the contingency and remove that subject home from the market, or is it an offer which is sale of another home? Is it contingent on another home selling down below that one? If so, is it a bona fide offer? Well, to answer that question, this often happens with an escalation clause. When you have an escalation clause which is triggered by another offer, another bona fide offer, and That's language that's in clauses for you to use. But what is a bona fide offer? How do you identify what a bona fide offer is? Well, in the escalation clause addendum, it's pretty clear. I'm going to switch over real quick here and see if I can pull that up. The bona fide offer is not one which includes the contingency for the underlying purchase to be contingent upon another sale. So if you've got your sale here and you receive an offer from a buyer on your listing, which will allow your buyer seller to purchase another house, does that bottom offer, is that considered a bona fide offer if it has a contingency which requires that home to be sold? It doesn't have an offer on it already. Then the answer is probably not. But that's a legal interpretation, and it's one that we can reasonably extrapolate from the escalation clause language, which specifies that it is not a bona fide offer if the property is contingent, if the offer is contingent upon the sale of the underlying property. So in that event, if you've got an offer where a property has not been sold, there's not an underlying sale on it, and they submit an offer, and your offer has an escalation clause, can the other offer ratchet that offer up if it's still subject to it being sold? Well, technically, under this definition, the answer would be no. But I know very well that there are agents out there, listing agents out there, that are using those offers, which are subject to a sale, to ratchet up escalation clauses. So I think it has to be very careful. You have to be very careful about the language that you use to make sure that you're not experiencing a situation where your escalation clause is being triggered by a non-bona fide offer. So it's something that you might want to include in the language of a counter offer or an addendum of some sorts to make sure that everybody understands what a bona fide offer is and what will cause the escalation clause to be triggered or a home to be removed from the market in the event another offer comes in and there is a right of first refusal in place for the buyer on that property. I hope that makes sense, but if not, call the Deal Doctor line at 616-490-0902, and we can do our best to help walk you through it. The problem with legal jargon is that it is only understood by some real estate attorneys. And I say real estate attorneys. Most attorneys who are not real estate attorneys don't understand it at all. And only some who know real estate understand it. More importantly, it's not understood between agents. A lot of agents don't understand the legal jargon that gets thrown around in this business, and certainly most buyers and sellers don't understand it. So if you're going to use those phrases like right of first refusal or bona fide offer, we have to clarify what that means in writing, or it's going to be very unenforceable. And let me explain what I mean. For example, let's take the issue of what stays with the property when you sell it and what doesn't. This is an area of frequent confusion. In fact, I got a text earlier from an agent about smart home technology, and I'll touch on that in a moment. But we've gone with the understanding that if it's a fixture, if it is attached, nailed down, screwed in, and so on, it remains with the property. Well, guess what? That's not quite as black and white as it used to be. It's a little more gray. And I'll explain what happened to me. It was a costly lesson. But I didn't specify in a purchase agreement that the hot tub was to be included. Now, the hot tub was on a cement pad specifically made for that hot tub. It was bolted down to the hot tub, down into the cement. It was hardwired with conduit. It was hard plumbed with plumbing going out underneath the cement pad. Now, I don't know how much it takes to be considered a fixture, but it would seem to me that that would be one. The seller took it. When the buyer arrived at the home for possession, they said, "Where's the hot tub?" And I said, "I don't know. It's probably something you may want to pursue in small claims court." So we met with the attorney. And you know what the attorney said to me? They said, "It depends on what the intent was." Ruh-roh. I knew right then I was in trouble because I hadn't put it in the purchase agreement. The question of what the intent was kind of a big one. Did the seller intend to leave the hot tub? It wasn't in the list of things, appliances. But even if it's in the list of appliances on the multiple listing, does that necessarily show intent? No, not necessarily. So when we get to issues like this, oh, by the way, that cost me $3,000. I basically gave the buyers a check to go out and buy a hot tub. So when we get into those situations where there's some question, eliminate the question. Make sure that it is clear, expressed specifically in writing within the purchase agreement about what's going to stay and what's not. If the appliances, for example, are listed on the multiple listing system, I know that we've had some situations occur where buyers walked into the house and said, "Well, where's the stove and the fridge and the washer and dryer?" They weren't on the purchase agreement. Well, but they were on the multiple listing card, listed, and I offered full price. It doesn't matter. If it's personal property that can be lifted and carried away like a washer and dryer, refrigerator, range oven sort of thing, it has to be listed on the purchase agreement as personal property remaining with the home as a result of the sale. It has to be included on the purchase agreement, or you could very well find yourself in court trying to defend the actions of not putting it on the purchase agreement. What about smart technology? Today we're seeing a lot of things like Ring doorbells, Nest thermostats. I installed a smart thermostat in my home, and it's great. But what happens when the home sells? Do I have a right to take that technology with me? This question came up, and the answer is, it's gray. And the reason it's gray is this. If it is perceived as a fixture, the way that the West Michigan Regional Purchase Agreement, for example, is worded, it says attached. Attached smart technology. Attached how? Is it attached if it's nailed down or screwed in? Yeah, that's pretty clear. What if it's held up by Scotch tape and attached to the wall by Scotch tape, for example? Is that attached? Probably not. Maybe. It's probably not a lot different than having a Wi-Fi modem sitting in the closet down in the basement. If you walk into a lot of homes, you'll see the Wi-Fi is sitting in the closet, in the back room or whatever. That's obviously personal property. Is smart technology like a Ring doorbell or a Nest thermostat, if it's not attached, first of all, the question is, can it operate effectively if it's attached? But, regardless of that, regarding a purchase agreement, the question is it attached, or is the intent of that smart technology to be transferred to the new owner? Wow, that makes it a really difficult legal interpretation, doesn't it? Because a judge could look at that and go, wait a minute, this technology was attached. It appears to me that the intent of the seller was to have that for the use ongoing beyond the sale of a house, and therefore the intent is that smart technology would stay beyond the closing. That's a tough one. So the way to clarify it is to include what is included in the purchase agreement, even though it is could be considered a fixture or may not be considered to be a fixture. Clarify it in the purchase agreement that the Nest thermostat and the Ring doorbell to remain with the home. It's easy and quick to do when you write the purchase agreement. It clarifies it for everyone, and you will avoid problems later by addressing it early on. The question that's going to get asked is, did the buyer make an offer believing that the smart device would be included? Was there a basis for that? In other words, was it included on the MLS? Did the seller intend to take it? Was it a reserved item on the MLS? All of those things are going to be questions if you end up in court fighting over this stuff. So deal with it up front. Spell it out. Make it very, very, very clear. Communicate in a manner not only to be understood, but so that you cannot be misunderstood. Let's talk about smart technologies just a bit more. What happens after the closing? What happens at the closing and beyond? Does the seller have an obligation to log off all smart device apps and eliminate themselves from the subscriptions that they may have? Where does it say so in the PA? Well, it's new technology, and our purchase agreements are still catching up with the changes in technology. And obviously the purchase agreements don't necessarily want to get involved in every little detail that has to happen. But I think it's very much like a utility where the seller has to remove themselves from their DTE account or their consumer's account and allow the buyer to come in and take over that account, transfer it, or the seller can terminate the service, and the buyer can come up and restart a new service. I think that's where smart technology is going to go, but I couldn't tell you 100% because right now the purchase agreement doesn't spell it out. Nevertheless, we can do it in the purchase agreement and stipulate that the seller will be responsible for removing themselves from any smart technology apps and or subscriptions on such and such a date. We can make it very clear. So, let's talk about when buyers get the keys. When does a buyer get the keys? Well, sometimes it is interpreted that the buyers will get the keys at possession, whenever that is. Let's pretend for a moment that it's going to be 10 days possession after closing for the seller. Does the buyer get the keys right away? Technically, it's their house at the end of the day of closing, so why wouldn't they get the keys if they own the property? But that's not how it's interpreted always in the real world, is it? Sometimes they don't turn over the keys until they turn over possession. Is that right or wrong? I don't know. The question is it in the contract? What does the contract say? Does it stipulate that the buyers will receive a set of keys as of the date of closing, once the transaction has been consummated? Oh, what does consummated mean? In a minute, I'll explain as it regards real estate transactions. The point is, we have to make it clear when those keys are going to change hands and what are the limitations of possession once those keys are exchanged. So, to answer my own question about when is a sale consummated, it is when the money changes hands. So if you have a closing on a Friday and the seller signs at 11 o'clock in the morning, buyer signs at 4 o'clock in the afternoon, and the offer doesn't get funded, what happens? And let's say you have possession at close. What happens? Is the seller required to turn over those keys to the buyer at 4:30 when the buyer has signed, even though it's not funded? Or does it not get funded until Monday, at which point possession occurs at that time, the keys get turned over? Well, again, That is a legal question, a legal interpretation of the contract, and we're not attorneys. So what happens most of the time? Most of the time, a seller is going to feel okay that the closing has happened, the money's there, it's simply a matter of formality of getting the money to the seller through the title company. Sometimes they won't. Sometimes they'll say, hey, this deal isn't a deal until I've gotten my money, so I'm not turning over the keys. Again, we can clarify these things prior to the closing so there are no surprise that in the event the funding does not occur until the next business day, the seller agrees to turn over the keys once all documents have been signed. That would make it simple and clear, I think. Or would it? When does closing or possession actually occur? I often do this when I have a closing coming up. I will send out an addendum to the other agent and say, possession to occur, keys to be delivered from seller to buyer at 5 o'clock or no later than 5 o'clock in the afternoon, 5 p.m. On December 21st, for example. So that there's very clear instructions as to what's going to happen, how those keys are going to get into the hands of the buyer, and when. Not 30 days after closing, because when do you start closing? In a situation like I just described, is it on that Friday when the documents were signed, or is it the Monday after when the transaction was funded? That's a tough one. And that really is a legal interpretation, again, which we really shouldn't be addressing, but we're always put in these positions of having to address them because the circumstance happened. So I would encourage you, if there's any confusion, if there's any question, that you deal with it ahead of time by creating an addendum and getting everyone to sign it so that everyone understands when the possession is going to take place. When I was in the advertising business, I know that other industries do this too, but every ad agency that I worked for had a thing called a conference report. And a conference report was a summation of what occurred in a meeting, whether it was in a conference call, in person, whatever it was. Somebody was responsible to go out and describe what had occurred in that conference, whether we had agreed to a timeline for an ad campaign to start or whatever it was. And I thought about that today when I was reading an article about communication, and I read the quote, which I've heard before, about communicating in a way not just to be understood, but so to not be misunderstood. And I remember that was the motivation, the goal behind communicating via conference report what everyone had agreed to in the meeting which had just taken place. And I would suggest to all agents that if you want to have good relationships with your clients, once you've had a telephone call or a meeting in person, put it in an email. Put what it is you all agreed to. For example, you meet with a buyer and you get them pre-qualified, or you send them to be pre-qualified. And then you talk about earnest deposits, and you talk about how we shop for homes and what we're looking for, and so on, what the price range is, what the areas might be, and so on. What would it hurt to take 5 minutes and write an email afterwards and say, hey, thanks for stopping into the office, or thanks for talking by phone, just so we're clear on the next steps. Here's what you're going to get pre-qualified. We're going to go out and shop for homes. And then we talked about earnest deposit, and here's what we need to be prepared to do, and so on. I think it would help all agents to have to demonstrate more professionalism if we can communicate and follow up with our clients to make sure that they understand or they are thinking on the same page as we are. And so that we can't be misunderstood. It's as simple as that. So that's really all I have to cover today, but going to call this for the year 2021. We're going to be back after the first of the year. In the meanwhile, I hope you have wonderful holidays. Enjoy them with your family, friends, and we will see you in January. Thanks for joining.